Welcome. My name is Jeff Cohen, and I'm the Managing Principal of the Chicago Office of Analysis Group. I'm joined here today by Scott Stein and Brenna Jenny of Sidley, Austin, as well as my colleague Miran Yanakamshin from Analysis Group to discuss today the use of statistical sampling to establish FCA liability. The slide presentation that you should all have is entitled Everything You Wanted to Know About the Use of Statistical Sampling to Establish FCA Liability, but We're Afraid to Ask. So today we'll discuss the setting for our discussion, some basic statistical principles, the case law, and as well as some reflections on expert analysis in FCA matters and how those trends may mirror precedent class certification work. All of you should be able to access the slide presentation. If you have any difficulties, you can email or chat with the CLE coordinator. To that end, I also understand that the CLE course code will be given later in the presentation. So let me introduce the panel. Scott Stein is a partner in Sidley Austin's healthcare practice in Chicago. Scott has represented clients in the healthcare and other industries in dozens of False Claim Act investigations and lawsuits, including matters involving sampling analyses. Miran Yanakamshin is a vice president in Analysis Group's Boston office. He specializes in data analysis, economic modeling, and is consultant on economic and strategic issues in a variety of industries, including pharmaceuticals, medical insurance, and computer software. Miran's calculated damages in a variety of False Claim Act claims, including off-label pharmaceutical promotional matters. Brenna Jenny is an associate in the healthcare group in the firm's Washington, D.C. office. Her practice focuses almost exclusively on False Claims Act litigation and compliance. She has managed internal investigations and subpoena responses, including by partnering with consultants on statistical sampling projects. Brenna has also advised on the process of government self-disclosures as a result of audit findings. In terms of my own experience over the last couple of decades, I've served as an expert in antitrust, securities, intellectual property, and statistical matters. I've worked on numerous topics in the healthcare industry involving insurance, providers, pharmaceuticals, and medical devices. With that, let me turn things over to Scott.
Thanks, Jeff. So to provide a little bit of background, the use of statistical sampling in FCA cases is not new. Sampling has been accepted as a means to quantify False Claims Act damages in cases in which liabilities either already been established or really isn't contested. But what we're seeing with increasing frequency is that the government and whistleblowers are seeking to use sampling to establish the fact of liability itself. More precisely, they're seeking to present evidence that a relatively small sample of specified claims are false, and then to extrapolate that finding out to a much larger universe of claims. In cases against large national providers involving thousands of claims, plaintiffs argue that sampling must be permitted because a claim-by-claim analysis would be cost-prohibitive, and otherwise widespread frauds would go unpunished. Defendants, by contrast, point out that permitting statistical sampling to establish liability creates a situation in which companies can be held liable for hundreds or thousands of false claims that neither the plaintiff nor the defendant can identify, based on proof relating only to a relatively small handful. This allows plaintiffs to ratchet up liability and settlement pressure exponentially. Now, in the administrative context, Congress has expressly authorized statistical sampling to establish overpayment liability. But Congress has not explicitly authorized sampling for FCA claims. Moreover, unlike administrative overpayment claims, False Claims Act claims require a showing that the defendant knowingly submitted false claims, an inquiry that frequently requires a claim-by-claim analysis. And the standards for admitting sampling evidence, like other scientific evidence, are the Daubert standards, which are stricter than the standards by which courts review agency determinations. The impact of this question, whether sampling can be used to prove FCA liability, is hard to overstate, as we saw within the last couple of weeks in a case against Consulate Healthcare, a chain of skilled nursing facilities. The relator in that case alleged that Consulate upcoded claims at nursing and rehab centers nationwide. The relator was a former employee who had worked at 2 of the defendant's 50-plus facilities, but she sought to use sampling to establish liability on a nationwide scale. Her coding expert pulled a sample of 600 government-paid resident days and evaluated whether the defendant had coded the claims correctly. The expert calculated overpayments of $42,000 associated with that sample of 600 resident days. She then had a statistical expert who extrapolated those results out nationwide, concluding that that sample of 600 resident days, which represented 1/100th of 1% of the total resident days in issue, resulted in over $300 million in overpayments. On a motion in limine, a federal district court in Florida held that notwithstanding concerns about the small sample size, the analysis satisfied the Daubert standards. 2 weeks ago, the jury issued its verdict. They found upcoding of 400 claims. Recall that the experts had concluded that upcoding of just 600 claims was associated with a total of $42,000. But utilizing plaintiff sampling analysis at trial, the jury awarded damages of $115 million, which yesterday were trebled by the court to $345 million. Again, based on an analysis of just 1/100th of 1% of the resident days at issue. Now, there are no Supreme Court or Court of Appeals cases squarely addressing the use of sampling to establish FCA liability. But last year in the Tyson Foods case, the Supreme Court rejected a categorical exclusion of statistical sampling to establish liability under the Fair Labor Standards Act. The Supreme Court held that whether sampling is appropriate to establish liability in particular cases will require evaluation of a number of factors, including the representativeness of the sample, the reliability of the methodology, the elements of the underlying cause of action, the harm to a defendant's ability to assert individual defenses, and the availability of substitute evidence, including direct proof. So with that in mind, let's now dive a little deeper into what exactly it means to use statistical sampling to prove FCA liability. I'm going to turn this over to Mira.
So we're going to use a recent Ketam case to talk through some of the challenges and pitfalls that can arise with statistical sampling. The defendants in this case, VistaCare, operate a chain of hospice facilities. Federal healthcare programs cover hospice care, but only for patients who meet certain specified criteria. One of the most pivotal is a fairly subjective certification by a physician that in his or her clinical judgment For years after she left the company, VistaCare engaged in a corporate-directed pattern of fraud. So to make her case without the trial taking years, the relator had to rely on statistical sampling.
So what do we mean by sampling? Sampling is the process of using a subset of a population to estimate characteristics of the whole population. The illustration below shows how this works. So on the left side, we have a target population of 60 individuals. And so we essentially, what we do now is take 6 people, or 10% of the population, and move them to the right onto our sample, the big red circle, and we analyze them to draw a conclusion about the target population. So in this instance, in our sample, we see there's 4 men and 2 women. And so we can make the characterization that the target population will have about 2/3 men and 1/3 women. Now, the benefit of sampling is that it allows characteristics to be understood without having to do a complete review of the target population. And this saves a lot of time and resources. In the VistaCare example that Scott and Brenda spoke about a moment ago, instead of doing a patient-by-patient review to determine medical necessity, the relator's expert used a sample of 300 patients from a target population over 12,000 hospice patients to attempt to establish FCA liability. Now, a critical question for many FCA cases is whether a sample is even necessary in the first place, or are there other reasonable options for using this full target population? Now, if you're dealing with about 500 or maybe even a few thousand people, you might not need a sample. However, if you're dealing with hundreds of thousands or millions in your target population, there may be no other alternative. Say you want to use a sample. How does that work? Well, the first thing you need to do is develop a sampling plan. And great care and thought need to go into this plan in order to ensure that the sample is created appropriately and analyzed correctly. The first step of the plan is to define a population. What group are you trying to draw conclusions about? In the VistaCare case, we are trying to draw conclusions about patients receiving Medicare hospice benefits. The next step is to select the sampling frame. At its simplest form, this is the list of which you draw from your sample. So this could be a list of facilities, patients, or anything else. In the VistaCare case, the relators expert used a list of patients. Next, you need to specify how do you go about selecting which elements to include in your sample. Now, the most familiar approach is just taking a random sample, where all the members of the target population have an equal chance of being selected. Another method that is commonly used in stratified random is a stratified random sample. This is particularly useful when there are large differences in the characteristics of the target population itself. For example, severity of disease could be one. You might want to look at having people who have very severe disease, but also look at a group that has mild disease and see if there's any differences there. In the VistaCare case, the expert used a stratified random sample. However, the stratification seems to have only been done on the time period, not any characteristics of the patient population. Once you have your method, you will need to determine how large of a sample you need. Now, this is an area where you need to balance the necessary precision of the estimate with the sample size. Larger, well-constructed samples will yield finer precision, but they also take additional time and resources and can be costly. And ultimately, it could also be unnecessary. If the analysis that is contemplated doesn't need very fine precision, generating a very large sample might not be worth it. In the VistaCare case, the expert determined the sample size based on available time and resources and decided that 300 patients was the right amount. After determining the sample size, data collection begins. It's very important to develop a structured plan that ensures the data is collected in a consistent manner. As with the VistaCare case, collecting the patient data can be challenging as different facilities may record the same procedure or service differently. So when moving on to the next step of data analysis, it is important to be careful not to draw conclusions based on incorrect data interpretations from the data extraction. And after obtaining the data, the next step is to analyze and extrapolate the results to the population that we discussed in step 1. So these are patients receiving Medicare hospice benefits. In the VistaCare case, one expert reviewed the medical records of the patients in the sample, and a statistical expert extrapolated to all patients. However, due to some flaws in the design, the extrapolation was invalid. So at a high level, most sampling plans would follow a similar path. With any sampling analysis, there are the possibility of errors. Some of these are avoidable and some are unavoidable. Really to get a sample that mirrors the larger population. There are two general types of errors that can occur, sampling errors and non-sampling errors. Sampling errors are errors that arise out of essentially picking the wrong members to include in the sample. Some common sampling errors include sampling bias and random sampling errors. Sampling bias occurs when some members of the target population are more or less likely than others to be selected. In the VistaCare case, there were two notable bias errors. The first is when the expert was looking at their sampling frame or their list of people to select to include in the sample, and there were duplicate records for some patients. This leads to the patients with the duplicate records to actually have a higher chance to be selected in the sample. And a second error was that the expert erroneously removed some patients from the population that he thought were duplicates but were in fact different people. Random sampling error is another type of error, and it arises when there's differences between the selected sample and the population that just occur by chance. For example, if all patients that were randomly selected came from one of the 20 or so VistaCare facilities, this would not mimic the population. However, this can still happen by chance because you are randomly selecting the patient. Random sampling error is unavoidable. However, as we will discuss in a moment, the randomness of the result can be better understood through the evaluation of the margin of error. Non-sampling errors are essentially a catch-all phrase for anything that's not a sampling error. And these are introduced through the data collection and the processing steps. And so over-coverage errors are when the sample includes data from outside the target population, and processing errors, another type of non-sampling error, can occur as a result of errors in the data extraction. In the VistaCare example, the relators made a non-sampling error by including claims for patients in the sample that was outside of the at-issue period. While no method of sampling is going to be perfect, there will always be some sort of random sampling error when working with samples. And the common way to evaluate this is through the margin of error. So this is the maximum expected difference between the true population estimate and the sample estimate. And this is typically expressed at a confidence level. So typically it's 90 or 95%. However, there's nothing magical about those numbers, but it's two levels that the courts have required. And a way to interpret what the margin of error is, or the confidence interval, is this will essentially give you a range of certainty where you can say, I'm 95% confident that the population estimate is between X and Y. For liability purposes, just evaluating the margin of error is not enough. One would need a benchmark in a false claims act case. What would the natural rate be without any allegation of wrongdoing? In the example below, we essentially bring these two concepts together to see how the margin of error and kind of a benchmark work. So starting with the left column, from the analysis of the sample, what we find is that there's a 5% of the claims happen to match the criteria that the expert would use for a false claims, to satisfy false claims. So with that, there's a plus or minus 3% margin of error. Now, how do you get to the 95% confidence interval? Well, what you do is you take your point estimate of the sample, which is 5%, and you add 3% to get the upper bound. So that's how you get 8%. And then, similarly, if you want a lower bound, you would subtract 3% from the 5% to get 2%. So your confidence interval is that the true population parameter estimate is between 2 and 8%. Now, you can't stop there. You need to think about, well, what would happen if there was no allegation of wrongdoing for certain facilities? And if you find that 4% is essentially what happens regularly when trying to figure out if the patient is eligible for hospice care, you compare it to what you found in your sample. So 5% is slightly higher than 4%. However, within the margin of error. So there's going to be some instances where the population estimate might be above the error rate, but there's many that are below. And so this is an area where an expert can opine on looking for statistical significance. So really, what is the difference? Is it meaningful? And does it really just occur by chance? In the VistaCare case, because the sample was not drawn in a random fashion, it essentially invalidated the margin of error analysis. And then interpreting results, the next step is really extrapolation. And so the key issue here is that the sample must be representative of the population. Samples should be analyzed for representativeness of the target population before extrapolation. This would involve testing characteristics of the sample and the population. It could entail verifying the age, the gender, the geographic distribution of the population, or whatever dimension is really critical to the case. In the event that the sample is not representative of the population, there are ways to correct for some differences, but not every difference. Having the foresight early on in the sample plan will be important to allow for the right data to be gathered and analyzed, and afford any expert the opportunity to correct for differences between the sample and population for extrapolation. In the example below, we're showing how extrapolation from a stratified sample could work. And so this is assuming that both the sample and the population are representative of each other. So on the left side, what we have is the sample, and the right is the population. And the top segment is the first stratum, which is dementia, and cancer is the bottom. And so essentially what you would do is look in your sample and look at what is the false claims rate. And so here, dementia is represented by a blue box, and cancer is by a green box. And you essentially would apply that rate onto the greater population. And that's how you get the larger blue box on the right and the larger green box on the right.
and then sum those up for your potential false claims liability. However, you can't just stop there. You need to take into consideration the margin of error because you have an upper bound and a lower bound because of the uncertainty with the sample. And so you would do the same analysis for the upper bound, but also for the lower bound. Now, with the VistaCare example, the relator's expert didn't evaluate whether the sample was representative of the population on a number of characteristics. And one particular one was the disease trajectory. So dementia and cancer are kind of two examples where patients would actually have a different disease trajectory. So they would deteriorate at different rates and may need hospice care at different points. Now, if you don't evaluate the sample that is representative of the population, you might end up in a situation where your sample consists of entirely of dementia patients, and you're projecting that onto a target population, which is maybe even predominantly cancer patients. So that seems to be an invalid to not require that the sample and the population are representative of each other. So in summary, there are a number of key questions to think about when working with the sample. What question are you trying to answer, and what population do you care about? How much accuracy or precision do you need, and is your sample large enough? Is stratification the right method, and if so, how do you stratify? When a sample is the best path forward, it's important to engage a sampling expert early in order to make sure that the process and the plan is correct and that no critical mistakes are made along the way that cannot be corrected for at a later time. And then circling back to where we began, when is sampling appropriate? In terms of allegation of fraud, if you have isolated allegation, it might not be appropriate, but if they're widespread or nationwide, it might make more sense. Size is another consideration. If there's hundreds or even thousands of claims, it could be possible to review every one, but if you have millions, it's probably unreasonable. And then if you have a risk of sampling bias, you could just wind up wasting your money because there could be something structurally or systemic to what you're trying to capture that a sample can't speak to. In most circumstances, whether or not to use a sample is really shades of gray as opposed to a black or white issue. This is an area where an expert can help sort through the pros and cons of using a sample. So that concludes our overview of the key statistical principles. Next, Brenna will be discussing the current case law trends.
While statistical sampling is a topic that has generally grabbed headlines whenever it has come up in cases, the issue has actually arisen in relatively few cases so far. Courts have demonstrated divergent approaches, and both plaintiffs and defendants face litigation risk as to how a court will respond to their arguments. Courts have primarily taken two approaches when asked to decide whether plaintiffs can use sampling to establish FCA liability. The first approach, pioneered by a court in the Eastern District of Tennessee in September 2014, is to allow sampling to be admitted so long as it passes Daubert standards, like any other expert testimony. In Life Care, the government intervened in a Ketam suit filed by former staff members of a skilled nursing facility. DOJ alleged that Life Care had pressured therapists to provide treatment that was more intensive than necessary. Life Care moved for summary judgment, arguing that the government could not meet its burden of proof as to the 54,000 plus claims at issue just by reviewing a sample of 400 claims. The court issued a really thoughtful opinion, ruling that the jury should be allowed to assign the appropriate weight to the expert testimony. DOJ obtained a similar outcome in Care when it intervened in a case alleging inappropriate hospice admissions. Now, this case is most well known for a pretty stunning sua sponte summary judgment for defendants on different grounds. But before that decision, the district court denied defendants' motion for partial summary judgment, which, like Life Care, had argued that the government just can't make its case as to the full population of claims at issue only by testing a sample. Renown Health is another provider case about supposedly inappropriate inpatient admissions. The court took a similar approach as Life Care and Care. Let's test the sampling through Daubert standards. The relator in CMC, the case we introduced earlier, is a lot like the relator in VistaCare. She worked at two of the defendants' facilities for a total of 5 months. Her last amended complaint asserted allegations as to 53 facilities, most of which she conceded that she had never even visited. Citing the voluminous discovery that was actually caused by the expansion of her allegations, the relator filed a motion in limine to admit expert testimony based on sampling that was yet to occur. DOJ filed a statement of interest in support. The court denied the motion as premature without a Daubert hearing, but made clear that in the False Claims Act sphere, there's no universal ban on expert testimony based on statistical sampling. As you saw at the start of our presentation, the court ultimately admitted the statistical evidence and the jury found it quite persuasive. The Agape Court broke with the trend in the spring of 2015 and refused to permit the plaintiffs to use statistical sampling to establish liability. However, the issue ended up being overshadowed by a question relating to whether the government has an unreviewable veto authority over settlements between defendants and relators. The Fourth Circuit actually just last month decided on interlocutory appeal that the government does have unfettered veto power, but it dismissed the sampling question as improvidently granted, and so the issue remains one that has not been addressed by any federal court of appeals. Now, Vistacare was the first big win for defendants on sampling. The court ruled that, at least in the case before it, statistical sampling was not appropriate. The court further decided that even if it were, the sampling could not satisfy Daubert standards, and Mirren gave you some examples of why that was earlier. The government intervened in the Prime healthcare case as well, which alleges that Prime charged Medicare for unnecessary inpatient admissions. Prime actually tried to address the question of statistical sampling head-on really early in the case by filing a motion requesting a court order prohibiting the government and the relator from using statistical sampling. In January of this year, the court decided that Prime's preemptive motion was premature. Now, when you read these sampling opinions, you can tell that courts are really conflicted by this question. One of the tensions underlying the debate is the question of when we should infer fraud. We're coming up on the one-year anniversary of the Supreme Court's decision in Tyson Foods. So far, courts in the False Claims Act context have actually not focused on the Tyson Foods factor relating to the nature of the underlying cause of action. If they do, it's one that may tilt in favor of defendants. Plaintiffs have to prove each element of the FCA by a preponderance of the evidence. Defendants have argued that each of the elements must be proven for every claim at issue. Accordingly, plaintiffs must prove that a set of claims is both false and the defendant acted with the requisite scienter. Finding a representative sample across both factors is more complicated than estimating mere overpayments in the administrative context. Plaintiffs may be more likely to succeed where they have a strong case for corporate-directed intent that pervades across the entire population, and their theory of falsity relates to relatively uniform objective assessments. In contrast, they would have a more challenging position where the intent of multiple actors has to be assessed across claims, and the falsity hinges on a subjective assessment. Some of the most challenging objections that defendants face are cost and feasibility. Even though the Agape Court refused to allow statistical sampling, the judge appeared to really grapple with the fiscal ramifications of his decision. What probably helped the judge overcome those implications was his suggestion, which the parties accepted, that they conduct a bellwether trial of 100 claims in the hopes that the outcome would serve as the basis for a negotiated settlement. But some courts, like the Vistacare Court, might be less concerned with cost and more concerned about preventing overreaching by relators who are guessing at a broader pattern of fraud. As that judge explained, if individual review of each chart were impractical, relator was not required to pursue all potential false claims submitted in 14 states over nearly a decade, of which she did not have personal knowledge. Courts may end up reaching a middle ground that accepts sampling in some circumstances, but cabins perceived overreaching by relators who are essentially extrapolating their own allegations to other time periods or segments of a company. I'll turn it over to Jeff, who will talk about some class certification.
So I think we take a step back for a moment, and as I alluded to at the beginning, one can't help but notice that there are parallels between the likely increase in the use of statistical sampling in FCA matters and the path that expert analysis has already taken in some other arenas, in particular, I think, the area of class certification. To begin with, in each, the sheer magnitude of data to review is job number one. In other words, what's tractable and what is practical given time and cost. The presence of large data and the corresponding need for sampling is even more pronounced when at the very heart of an FCA claim is the notion that the plaintiff is trying to prove a pattern of widespread corporate-directed fraud. So many of the same considerations that Miran discussed about whether a sample is more or less appropriate in a particular False Claims Act case, for example, the similarity of claims or the existence of direct proof, require specification techniques similar to those used in determining whether a class-wide analysis would be appropriate. Now, these considerations are, of course, the subject of expert analysis, and the question in an FCA matter of whether claims are sufficiently similar to be the subject to proof by sampling are similar to the questions of whether, say, purchasing patterns of putative class members are sufficiently similar in a pharmaceutical class case certification setting. Increasingly, too, we observe that the courts are more and more willing to hear expert testimony of a highly technical nature. This may be because the large cases being brought require such methods, or it may also just be because of the increase in computing power, what's commonly thought of as Moore's Law, that now more sophisticated techniques are possible. In any event, I think for those of you listening who are familiar with the class certification stage in antitrust or securities litigation, you're well aware that the expert phase has started earlier and earlier in the process. And if nothing else, the Supreme Court's decision in Comcast has moved up the schedule for both plaintiffs and defendants. As we discussed earlier in this presentation, once a sample plan has been agreed upon, it sets in motion a series of discovery and expert activity that can be very costly to unwind later. And for example, sometimes the sampling decisions and even the mistakes associated with them can be shockingly simple. One might design a random sample that, suppose, picks every even-numbered claim, only to find out later that even and odd-numbered claims are not themselves randomly distributed. Or one might be interested in sampling a particular field that's populated in some claims, and then turns out it's missing in others. What protocol was set with respect to treating missing variables? What does one decide to fill in the missing information or redraw a new claim from the pile? Should one replace the pile? Replace that file from the pile? Thinking about the sample design early on can minimize what should be thought of as the sample's path-dependent costs later on. So maybe to summarize this overview, as it was in class certification with respect to regression analysis, it is now likely in FCA matters that many defendants will no longer be comfortable to wait and see what the plaintiff's sampling expert shows. Defendants will likely want to think affirmatively whether one's own sampling analysis is ultimately produced or it's just used for case strategy. Maybe one last point to that end, it may be particularly helpful to engage consulting experts who are not subject to the same requirements as potential testifiers. Now is perhaps a good time to give the code for the CLE, which is SACLE 17-66. I'll say that again, SACLE 17-66. Back to you, Scott.
In the course of the registration process for this, we received several questions from participants which we've endeavored to try to answer in the course of the presentation, but if we've not addressed them, we would encourage those individuals or anyone else who is participating in the webinar to submit questions, which you can do through the interface. So what do we take away from this? There are several key points. First of all, as you saw from Brenna's, the courts are of a mixed mind at this point about the appropriateness of statistical sampling in FCA cases, whether it should just be governed by the Daubert standard, like all other scientific testimony, or whether there's something different about using these sampling in the context of fraud that renders it either inappropriate in FCA cases as a whole, or at least in particular types of cases. But for planning purposes, I think those of us who are involved in False Claims Act investigations and litigations need to be prepared for the possibility that courts are poised to allow statistical sampling to support FCA liability, but equally important to understand that that it's very difficult to know in advance whether a court will allow it or not. And so for that reason alone, it bears keeping in mind that you need to be prepared to use it. Second, does your compliance program address sampling issues? So when a problem percolates up through compliance, you need to ask, is this a larger problem? Is it limited to the particular issue that's being raised, or might it affect other facilities or claims? What is the root cause? Is this a systemic problem or not? Do you have a policy to guide when the use of sampling is appropriate? And if so, whether legal or compliance or both need to be involved? Do you have a policy that establishes timeframes for completing the analysis and what needs to be done depending on the results of the sample? Have you thought about when sampling suggests that you might need to refund overpayments? And if so, how exactly do you go about doing that in a situation where those sampling-related overpayments aren't tied to particular claims? These are the kinds of things that that large national providers and suppliers need to be thinking about before you get that subpoena or that False Claims Act complaint. It's also important to try to determine early whether the government is pursuing a sampling approach. And sometimes, for better or for worse, you can tell that from the government subpoena. You might get a subpoena that you can tell essentially seeks a sample or samples of claims, which indicates that they're sampling. But sometimes the government will be using sampling, but you won't quite know what they're doing. Brenna mentioned the Agape case, which was the one in South Carolina. What was interesting about that case is this was a non-intervened case in which the relator and the defendant had negotiated a settlement. But the government stepped in and opposed the settlement on the basis of their argument that said that they thought that the settlement was not high enough based on their own undisclosed sampling analysis. And the district court ultimately overruled the government's objection and found that the use of sampling wasn't appropriate in that particular case, and that the government's veto of the settlement was unreasonable. That went up, both of those determinations went up to the Fourth Circuit on interlocutory appeal, but within the last few weeks, the Fourth Circuit ultimately punted on the sampling issue, finding that the government had an unreviewable veto right. So now we see what happens. The case goes back down to the district court in the posture that the settlement is being objected to based on the government sampling analysis. It's also important to get an expert involved early to try to direct the course of the litigation. And then finally, even if the government is not pursuing sampling, or you're not sure whether they're pursuing sampling, you should consider sampling yourselves to ensure a fair methodology. One last plug here is that this issue of sampling is something that we at Sidley have been following closely and writing about on our False Claims Act blog, Original Source. If you're interested in learning more about it, you can go to the blog and either just view the blog periodically or sign up to receive email notifications of new posts. All right, well, with that, we want to thank everyone for participating today.
Thank you.
Thank you.